Good morning, everyone. We are Group 2. I'm Sally. Today, our group will discuss the court cases on sickness allowances and maternity protection. This is our content page. Let's start with the introduction. Today, our course will including 3 ordinances, which are Employment Ordinance, Employees Compensation Ordinance, and Sex Discrimination Ordinance. And the details will tell you more before our case. Then let's start with the first case on sickness allowance. This case will having their employment ordinance on sickness allowance, but this part already taught by Fanny before, then I won't explain too much. Then talk about the timeline. This case is Wong Chek Wai sue 5-Star Wine Limited. Wong Chek Wai is the claimant who started to work for 5-Star Wine Limited since 30 April 1998, and Mr. Wong worked in there as a sales manager with a 20,000 monthly basic salary, with 8% commission on sales volume, and entitled to have double pay of 1 month basic salary. On 1st August 1998, Mr. Wong basic salary reduced it to 15,000 Hong Kong dollars. And then unfortunately, on 21st May 2000, Mr. Wong was hospitalized for acute labyrinthitis and need to have sickness up to 1st August and extended to 13 August. On 2nd August 2000, Mr. Wong sent a notice of constructive dismissal to the company to take effect if the company did not pay him, especially the sickness allowance within 7 days. But in fact, the company didn't pay him any money. And then the court case exists, and there are having 5 events that Mr. Wong want to claim. The first one is sickness allowance. The company alleged that Mr. Wong absent himself in mainland China since May. Therefore, the company argued that actually they can't find him and don't know what happened to him. Therefore, can't pay him anything. And the second event is the unpaid wages. The company alleged it again because they say that the both parties already verbally agreed to reduce their salary from 1,000 to 10,000 per month since March, but Mr. Wong not agree and even don't know what happened. Therefore, think that the company pay less to him. And the third one is annual leave pay. Company argued that Mr. Wong actually was not entitled to have the annual leave pay because he having a flexible working hour and don't need to work on Saturdays. And the fourth one is double payment. Company refused the liability and alleged that already on 25th January, there was a notice for the employees in their company and informed them there are no double pay, and stated that Mr. Wong already agreed, same as other employee. But Mr. Wong denied it and refused to sign. The fifth one is about commission. There is a consensus for employees and employer that the commission was only paid until the invoice was settled down. But Mr. Wong gets sick and the company declared that the invoice was not or settled down or even will be deducted the commission. Then we can see the judgment from the presiding officer. Start with sickness allowance. It is lucky that there is a representative from the company, who was Mr. Chan, who visited Mr. Wong at the hospital once already. Then the company also received the notice of constructive dismissal from Mr. Wong. Then the company can't to have any quibble anymore. However, company still refused to pay it up. Why? Because Mr. Wong lied to the company because their invoice still showing defaulted after the customer delivery. Then the labor department arranged a meeting to discuss this event and conclude that the business invoice were already shown to Mr. Wong. Then the presiding officer rejected the company can't find Mr. Wong and need to pay the sickness allowance for $28,258 Hong Kong dollars. And then it lead an extra event because Mr. Wong lied to company. Then the company raised allegation of fraud to Mr. Wong, and this case passed to police investigation, and the invoice needed to be evident for trial for another judgment. But this will not affect the our cases in the future. Then talk about the other judgment, including unpaid salary, annual leave pay, and double pay. There was a factual dispute because their employer can't prove any evidence to the court to the labor department to show that there is reduction on salary, or Mr. Wong don't have annual leave, or change their employment to cancel double pay. Then the presiding officer award Mr. Wong to claim with 8,677 and 40 cents for unpaid salary, 8,081 and 90 cents for annual leave pay, and 15,000 Hong Kong dollars for double pay. And finally, the commission. As I mentioned in the previous slide, the Labor Department already judged that the invoice already settled by Mr. Wong. Then company is liable to pay back the commission in full with 10,493 and 90 cents. Then here is the breakdown of the claims. There are 5 events and total claims is 70,510 and 60 cents. From these cases, we can see that no matter employees or employer, they both have some mistakes. Like employees, he didn't tell the company he got sick or he need to take the leave for how long period. For the employer, if there are some changes in the employment contract, the company didn't have any record for proof or evidence. As a result, I think that it is better to have set up a company policy. Like in this case, if there is a sickness policy with procedure, it is better for company, for the employees to notify the company or the direct manager, like in a casual way, like call, WhatsApp, or SMS, to tell the company immediately. And secondly, by a formal way, like email or automated HRM system, if the company have as a record. And finally, it is very vital to have medical certificates in order to verify the leave, the leave application or sickness allowance. And the second practice I would like to recommend is making information more easy to access, like HRM system or company intranet. Even it for some comparatively small size corporation, maybe not easy to afford such platform, but I think it is really important because the system allow employees to self-serve themselves anytime, anywhere. And for application, they can have internal annual leave application, allowance application, or information for to access anytime, like the company policy or procedure if they need, or see whether the record or changes already have. Then I hope that these two practice can help company eliminate their misunderstanding and conflict during the employment relationship. Then I'll pass the time to Heather to talk about the second case.
Thank you, Sally, and I'm Heather. I'm going to talk about the second case study on sickness allowance. The second and third case study would involve employee compensation ordinance. There are 4 sections are included in the following cases. Section 5, employees' liabilities for compensation for death or incapacity resulting from accident. Section 9, compensation in case of permanent partial incapacity. Section 10, compensation in case of temporary incapacity, and Section 10A, payment of medical expenses. Then I'll talk about the timeline of case 2. Tang Yam Kao, who is a plaintiff, sued his company Key Asia Engineering Limited. On 13 October 2010, Mr. Tan was employed by Key Asia as a carpenter. Key Asia ordered him to execute some carpentry work at a premise situated in an apartment. Besides, Mr. Tan was required to cut a board by using a bench-type electric circular saw in the workplace. In the picture, you can see that it is the standard of using. Next page, please. In the picture, you can see that it is a standard of using electric circular saw. However, the reefing knife is not fit in a direct line behind the electric circular saw. When Mr. Tan was cutting a board, the uncovered rotating blade were completely stripped above the branch. Then Mr. Tan's left hand was cut accidentally. Mr. Tan immediately went to A&E department of QMH, and the orthopedic confirmed he suffered from complex multiple deep structural injury and psychiatric impairment. During the period from 20th October 2010 to 1st November 2010, Mr. Tan attended occupational therapy in QMH and completed the physiotherapy treatment for 55th time. And he also attends the career training in this period. During the period from 10th November 2010 to 13 May 2011, based on the medical record, Mr. Tan received occupational therapy for 7 times, and the results shows that Mr. Tan's overall performance are disqualified his previous job requirement, so it is suggested him to change another job. On 2nd June 2011, Key Asia proposed to answering disputing liability, and he claims that Mr. Tan was not an employee when the accident happened. On 26 August 2013, Dr. Fu carried out a comprehensive medical examination of orthopedic condition to Mr. Tan, and he appraised that the damage to the whole person and the loss of earnings capacity of Mr. Tan are 13% respectively. And on the 26th November 2013, Dr. Chow interviewed with Mr. Tan, and he thought that his mental status is dinosaur of adaptation disorder with low mood, and his mental conduction mainly comes from this physical hurt, and this caused the permanent mental disorder, and the loss of income capacity are 4%. Here comes to the judgment. The court mainly considered that Mr. Tan's loss of earning capacity as permanently caused by his injury in the accident, and he accepts all the evidence from Dr. Fu and Dr. Chow, and also he found that his left hand injury and the corresponding residual disability and his psychiatric impairment described above were caused by this accident. So the compensation under Section 9 is $263,160 in total. And second, the actual number of sick leave days as certified by attending government doctor. Mr. Tan is entitled to claim for the Section 10 compensation with the loss of first year and the second year. And also the court satisfied Mr. Tan suffered total temporary incapacity, and such total temporary incapacity was caused by this accident. So he also can claim this loss in the third year. Therefore, the compensation under Section 10 is $595,586. Besides, Key Asia need to compensate all the medical expenses, and in total is 15,222. So here comes to the breakdown of the damage. Mr. Tan can claim 873,968 in total. Here are two suggestions on good management to employees and employers. Since Mr. Tan's left hand is cut by electric circular straw, and there is no protection to the employees in this workplace. So it is suggested the employer should provide safety protection in the workplace. The minimum requirements for an employee are to provide the goggles and face stacks, and this can pretend the material get into the eyes and nose. And also they can provide the G-clip to ensure the board can stick closely to the table. And this can make sure the workplace is safety in order to reduce any accident. Second, since the employer, Key Asia, did not accept Mr. Tan as employees on 2nd June 2011, it is lucky that Mr. Tan has evidence to prove that he is working under Key Asia. And the court is also accept this evidence. So it is suggested two parties should sign the employee written contract. The written contract can provide proof of what they are discussed in between both parties and reduce the risk of dispute regarding payment and responsibility. And this also can specify details of the termination of the contract. I hope these two suggestions can help for the employees and employers. Then I will pass the time to Sunny to talk about another case of employees compensation ordinance. Sunny, please.
Okay, thank you, Heather. Then I would like to talk about the third case of the sickness allowance, which is emphasized on the injuries at work. This case was happened between the plaintiff Chen Chi-man and two defendants. And the defendant one is the Sai Han Sen, who is the subcontractors, and the defendant two is the Wang Chi-lan Sunny, who is the principal contractors. And the plaintiff, Mr. Chen, was a demolition worker, and he was employed by the first defendant, Mr. C, at the wages of 700 per day without double pays or bonus. But after for the 10.1 months before the accidents, his monthly salaries was about 14,700, which was his 21 days salaries. Okay, let's talk about the accidents. On the 28th July in 2008, at around 10 a.m., Mr. Chen was instructed by the Mr. C to work with co-workers to demolish the garden's platform at the second floor, but suddenly parts of the concrete slab collapsed. So as a result, he fell down from the second floor and suffered from the personal injuries. Then he was sent to the hospital for treatment. The CT should display that there are multiple rab fractures of Mr. Chen's. And then because the after Mr. Chen has been hospitalized for 11 days because his health conditions remain stable, so he was discharged in 7 August in 2008, and in 15 July in 2009, Mr. Chen started to accept the physiotherapy treatment, and he was improved over 13% after 9 sections of the treatments. And on the 26th August in 2010, the Employees Compensations Ordinary Assessment Board identified the injuries of Mr. Chen as the reps fractures resulting in back pains and non-verifiable radicular complaints, and the loss of the earning capacity of Mr. Chen was assessed at 5%. And during the period between the 28th July in 2008 to the 26th March in 2011, Mr. Chen has been given with a total 838 days leaves intermittently. And then after the leave, Mr. Chen has tried to return to work. So he applied 3 jobs. The first one is in the May 2011. He worked as a general worker at a mental film work site, but he quit the jobs for after 13 days because his persistent pains has had a huge impact on his work. And then the labor departments gave him a referral for a security guard position at the Park Central, but he also was not engaged to the work because his Chinese language levels is unqualified, and so that he could not prepare a written report properly. And in August 2012, he applied for a security guard, but he only employed as a cleaning workers with a much lower salaries, which was about 6,944. And he also complained that he had to drag a 40 to 50 catties and meters long horse dozens filling with waters. So he quit the job after 40 days and with an earning of about 9,000. So let's talk about the judgment. The court finally ruled in favor of Mr. Chen, and under Section 5 of the Employee Compensation Ordinance, it states that subject to the subsection 2 and 3, if in any employments, personal injuries by accidents arising out of and in the course of the employment is caused to an employee, his employer shall be liable to pay the compensation in accordance with this ordinance. So it's obvious that Mr. Chen's accidents happened during his work, so the judgment on the liability was entered against the defendants with damage to be assessed. So the first head of the damages is the pain, suffering, and loss of amenities, which is called the PXLA. In assessing a PXLA award, the court encountered previous decided case for comparable injuries as a guideline for him to identify the level of the award. So the court considered 2 cases. One was award with 300,000, and another's was compensated with 350,000. And so the court saw that the injuries in both cases are more severe than Mr. Chen, so he gave him appropriate award of PSLA, which was 250,000 100,000 for the CLIF. Although the CLIF has been approved by the assessment board, but the court is not bound by the CLIF certificate to conclude that the plaintiff could not work on certain days. So having considered all the evidence, the court thought that Mr. Chen could not return to work until 26 March in 2011. So the CLIF period should be 32 months. And after the calculations and including the provisions of the MPF, Mr. Chen is entitled to claim about 564,000 for the CLIF. And for the 3-month allowance, because Mr. Chen could not return to his pre-accident job because the jobs require him to lift heavy objects, but he can find a more lighter duties, such as the security guard or the cashier. So the court gave him a reasonable period to look for a job, which is 3 months. And after the calculations, he can claim for the 44,000 for the 3-month allowance. And he also can claim the 250,000 for the pre-trial loss of the earning. For the post-trial loss of earnings, it means that Mr. Chen may feel the loss of the future earnings because of his pain. So the Mr. Chen do not exactly ensure that he will be retired after the 65. So the court run down the multipliers to 10, and the causes for the future earning is about 1.1 million. And for the loss of earning capacity, because Mr. Chen, the court accepted Mr. Chen's exactly had some disadvantage in the labor markets because of his pain. So he gave the Mr. Chen's a loss of earning capacity, which is 27,000. And he also claimed a special damage, including the medical expense, traveling expense, and tonic food. And the court allowed it and compensate him with 29,000. And the Mr. Chen is also entitled to the interest and the cost of the actions. This is the breakdown of the damage. As a result, the total number of Mr. Chen can claim that is 1.875 million. And then what things we can learn from these cases? There are 2 suggestions for the employers and employees. The first one, the employers should provide the support for injured workers' return to work. In the case, it's obvious that Mr. Chen has a difficult time to seeking a job because of his pains and reduced working capabilities. So he's forced to accept a job with a lower job requirements as well as the lower incomes. So the company should provide a re-employment service such as the vocational consulting, job seeking skills trainings, job analysis, such as those services for the employees to help them return to work. And if the employees is not able to handle the pre-accident work, like Mr. Chen, so maybe he cannot lift the heavy objects, the employer should provide other alternative vacations in the company to satisfy his skills and physical abilities. And in Hong Kong, the Occupational Safety and Health Councils also launch constructions and designative industry injured employees return to work pilot schemes, and it also invite the employer to join these schemes to provide assistance for the injured workers to return to work and keep contributing to the society and their family. And for the second suggestions is for the employees. I think the employee should be cooperative and responsible. The first one, he should cooperate with the treatments and any requests by the insurance companies. It's very common that the insurance company may ask you to be seen by an medical or doctors or medical services of their choosing for an independent medical examinations because they would like to avoid the cheatings. So if you face these situations, you should agree to be examined because if you refuse their requirements, it will raise many suspicions. And the second part is you should be responsible for the action outside the work. It means that you should be honest to explain your work, and you should make up injuries or exaggerate the injuries because many insurance companies may hire the private investigators investigate your degree of the injury. If you make up your injuries, you will face more serious problems. And so it suggests that for the employees should to be honest, to explain your injuries, and for the court and insurance company for a more fierce judgments. Then I will pass the time to Jeffrey to talk about the maternity protections.
Thank you, Sandy. So I'll now talk about some case and some regulation about maternity protection. First, in the employment ordinance, I quoted some parts that are related to my case later on, and it's about maternity protection. The first thing is that after a pregnant employee has served the notice of pregnancy on her employer, the employer shall not terminate her continuous contract of employment after she show you the official medical certificate of confirming her pregnancy. And the second thing is if a pregnant employee has served such notice on her employer even immediately after being informed of the termination, the employer shall also immediately withdraw the termination of notice. So I now introduce my case. This case consists of three main persons. The first person is the claimant, Walia, and the first respondent, Mr. Yip Hoi Sun Terence, and the second respondent. So Walia is a domestic helper came from Indonesia in 2008. And on April 2012, she was employed by Mr. Yip, the first respondent. And you should pay attention that she was employed by Mr. Yip, the first respondent. So in September 2013, Mr. and Mrs. Yip observed that Walia's tummy was very big and suspected she was pregnant at the time. On the 1st of October, Mr. Yip, the second respondent, required Walia to urinate into a potty in the toilet to conduct a pregnancy test. And Walia didn't voluntarily since she also wanted to know about the test result. And the pregnancy result showed that the pregnancy status is positive. And later that day, Mrs. Yip brought Walia to seek medical advice from a doctor for confirmation, and the doctor did confirm Walia was pregnant at the time. On the next day, Mrs. Yip brought Walia to a hospital intended to seek an assessment of abortion. However, on that day, they were unable to obtain such service, and they gave up the idea of aborting the child. So shortly afterward, Mr. Yip, the first respondent, required Walia to sign on a termination notice after she was confirmed that she was pregnant, and she was now given a copy of the termination notice as well. So on 26th of October, before the expiry of her employment contract, Walia was already demanded to leave the residence at that time, and she was given 5,000 as wage up to the 2nd of November 2013, which are supposedly the closing date of her employment contract and the airfare for her to fly back to Indonesia. However, on that day, Walia haven't fly back to Indonesia. She stayed in Hong Kong and seek some help from some NGO organization. And on the 4th of December 2013, Walia delivered the baby, but the baby was given up for abortion. So this is pretty much about the case, and I will now talk about how the judge see this case. Next slide, please. First thing first, I've emphasized that Valir was employed by Mr. Yip, and Mr. Yip was not the employer of Valir nor the employee of Mr. Yip. So, if there are some crime, discriminating crime that committed by Mr. Yip, supposedly they are not related to Mr. Yip. But the judge found that because of their marriage, he considered Mrs. Yip as an agent of Mr. Yip. Therefore, the discriminating action conducted by Mrs. Yip were also liable for Mr. Yip. So, in this case, there are two main thing that the judge have mentioned about is the sex discriminating and the pregnancy discrimination. First, the court found that Mrs. Yip was liable for sex discrimination since she required Valir to urinate into a potty to conduct a pregnancy test. And because of what I've just said about the agency problem, Mr. Yip was also found liable for the action of Mrs. Yip. The court indicated that not only the employer could not ask their employee to conduct a mandatory pregnancy test, but they also cannot ask about the pregnancy status of a female employee, or else this act will be constituting as sex discriminating on the ground of treating a female employee in a less favorable treatment, since a male employee would not be asked the same questions such as, are you pregnant or not, or can you conduct a mandatory pregnancy test for me? So Mr. and Mrs. Yip were found liable for sex discriminating for this. And also, Mr. Yip was also liable for his acts of pregnancy discrimination. The reason that the judge found this is because Malia were required to sign the termination notice shortly after she was confirmed of her pregnancy by Mr. Yip. And he also demanded Malia to move out the property before the expiry of her notice period. And the judge found this act is constituting a breach of implied term and mutual trust and confidence. It also breached the employment ordinance of pregnancy protection, and it is unlawful dismissal. However, on that day, the court couldn't hear any argument about the remedies and damages from both sides, so they set aside a date to discuss the remedies and quantum. But there are no records to be found shortly afterward. But after my studies on the similar cases, I found that there is a pattern that we could reference from. The court usually would granted the claimant have loss of income because of the termination until she found a new job, and there will be a maternity 10 weeks maternity leave, and the income loss from there, and some compensation of injuring the feelings of like being sex discriminating and pregnancy discriminating. So I would like to talk about some good management practice that employers should learn from this case. The first thing is to respect the pregnancy privacy. Under no circumstances, the employer should ask an employee to conduct a mandatory pregnancy test nor ask about their pregnancy status, or else this would be constituting as sex discriminating as mentioned before. And the employer should make accommodation after the employee informed that she is pregnant, or else you should treat her as a normal employee and assign her normal duty. The second good management practice is that you should, as an employer, you should show more tolerance for a pregnant employee. Only under true circumstances that an employer can terminate a pregnant employee, which are summoning dismissal because of some serious misconduct, or the employee have not passed the probation period, which is not more than 12 weeks. But it's highly recommended the employer should not terminate a pregnant employee even on those some misconduct has been happened because pregnant lady is very hard to find a new job in the society in general. So therefore, if you terminate her, she will be losing her financial pillars, and therefore you should show more tolerance toward the pregnant employee and make suitable accommodation catering for the pregnant ladies. So there are also some things that we can learn from this case as a field of sight of an employee. Is Valeria did very well. She chose to visit some NGO and consult about her rights, and which is what we should do more. If you think your right is being violated, you should consult a right with some trustworthy organization or person so that you can protect your right and you can seek justice because after their consultation. And you should also learn more about your right and try to reason with your employer if it is possible, if it is reasonable that your employer is able to communicate with you. Because if you try to reason with your employer, the employee might have understand the situation and you can avoid all kind of trouble that went afterward. So this is really much about this case. I'll now pass it on to Ashley to talk more about it.
Thank you, Jeffrey. I'm Ashley, and today I will talk about the case one on pregnancy discrimination. We have learned the sex discrimination ordinance by Fanny before, so I will not explain too much. Today we will mention the following three sections. It's about the discrimination against applicants and employees, and discrimination against pregnant women, and discrimination by way of victimizations. And then the case one is between the Holman and A Master Consultants Limited. The plaintiff is Ms. Lau and the defendant is E Master. Because the company has no legal representative, so the respondent is the company's director, Ms. Zhi. Now I will introduce the basic situation and timeline first. eMaster is a human resources consulting company. The nature of this company service is to recruit people and arrange them to work for the relevant government department by a loan. However, the responsibility of the employer is entirely borne by the eMaster. Ms. Lau was loaned to the Education Bureau for work as I just described, and her position is project officer with monthly salary about 15,000 Hong Kong dollar. And then, when the contract was about to expire, Ms. Lau provided her latest resume in accordance with company's request and had conducted an interview. Ms. Zhi called the plaintiff to inform her the interview was successful and also verbally promised she will continue to hire Ms. Lau to work. On October 25, they signed the new employment contract, and the contract period starts on November 24, and the scope of work is the same as before, but the monthly salary is increased to 17,000 Hong Kong dollars. Actually, Mr. Lau knew she was pregnant in August and received a pregnancy notice on October 4. After signing this contract, Ms. Lau gave the pregnancy notice to the company. And on October 26, Ms. Zhi called Ms. Lau to tell her that the renewed labor contract has been cancelled and asked her to return the contract. The reason is because they think Ms. Lau was dishonest by delaying submission the pregnancy notice to the company. And the next day, Ms. Lau immediately complained to the EOC against eMaster, claiming that the company had discriminated against her because she was pregnant. In order to solve the complaint on October 13th, eMaster offered a new contract to Ms. Lau, but the contract period has to start on November 25. Ms. Lau went to EOC to cancel the complaint on November 1 and sign the new contract. And then in December, when Ms. Lau applied for her maternity leave, E-Master informed her that it should be unpaid because she didn't satisfy the required period of continuous employment. And in March 2011, Ms. Lau, claiming the E-Master had treated her less favorably by imposing a one-day gap between her two fixed-term employment contract in order to break the continuity to avoid the maternity leave payment. And next, let's look at the court's judgment. The court held a one-day interval between the expiration date is a discriminatory act, and because it is violates Section 11 and Section 8A of the SDO. Obviously, the reason why the company withdrew the contract with Ms. Lau was entirely because she knew the fact the plaintiff was pregnant. So the court held in favor of Ms. Lau, and his employer should be liable to pay the compensation. And then you can see the breakdown of the damage, which can clearly show the amount of compensation. First is the damage for injury to feeling is about 15,000, and then its materials leave payment is 20,072.74. And the third one is exemplary damage for its intentional discrimination is 20,000 Hong Kong dollars. And then it's about the loss of income for the one-day gap. It's about 696.97. And then total claim is 90,769.71 and include interest and legal fees also. And in order to make employers and employees can better face this situation, in this case, I made the three suggestions. This is mainly for the employers, improve the relevant regulations for the defects, such as issued a policy on handling of pregnant employees. The company can use clear discipline to deal with such a special situation, not only just dismiss pregnant employees. On the other hand, company should require employees to provide their medical reports by the company before signing the new contract, maybe do the body test first, and it can help the company confirm whether the employee's physical conditions meets the company's needs. And second is about provide a communication platform for the employees and employers. It can help employer better understand the needs of employees. Employees should respect employers more and give them reasonable ways to express their demands, and it can reduce the conflict between them. And for employees, they should not hide their true situation before signing the contract. This is also related to integrity of an employee. And last one is enhance the effectiveness of protections against pregnancy discrimination. Employers can promote the awareness of legal protection of pregnancy discrimination in the company. It can help popularize the law in the company and the society also. Every employee should be familiar with the law on pregnancy discrimination protection also. This will help them to protect the rights they deserve. And now I will pass the time to Kelly to talk the case too.
Thanks,
Kelly,
Ashley.
please.
Thanks, Ashley. Then I will talk about another case under pregnancy discrimination. This is a case of labor dispute between the employee a product manager in Well's pharmaceutical marketing division, Chang Ying-Kwan, who is a person mainly involved in this case. And her first entrance into work was in July 1995. And around 2 years later, she became pregnant in September 1997, and the employer, Wealth Hong Kong Limited. Throughout the whole relevant period, Lawrence was the president and the managing director of Wealth China and Hong Kong operations. The general manager of Wealth in Hong Kong was Jackson Fang. In the chain management was Richard Kwan, the manager of the PMD. In that division, there were 4 main product managers, including Ms. Chang and Francisco Liu. They are under the same level in the position. Next, please. And then is a timeline of the case. On October the 23rd in 1997, at a meeting between Ms. Chang, Richard, and Iris, the Wealth Human Resource Officer, Ms. Chang was presented with an ultimatum by Richard that she should resign or be demoted to her position. And on October the 27th in 1997, Ms. Chang complained to the EOC that the requirement by reason of her pregnancy, then she suffered discrimination by victimization due to her complaint to the EOC. And on October the 31 in 1997, Wells received a letter from the EOC informing that Ms. Chang had lodged a complaint of discrimination due to her pregnancy and realized that a complaint had been made. Next. Ms. Chang was not given a salary increase in 1998 when other employees received salary increases. On July the 6th in 1998, after attending an antenatal examination, she received a warning in written about alleged unauthorized leave. She was considered didn't give notice before her leave. Ms. Chang started her maternity leave in May, and in July she came back to her position. And in 1999, her salary increase was 2.3%, which is lower more than 1 point than the others in the same period. Ms. Chang had now reached the point where she could no longer feel able to work at Wells. She realized that her career in the company had ended and she couldn't expect any further advancement. She resigned on July the 28th in 1999 after she finished her leave. Finally, in 2000, Ms. Chang decided to immigrate with her family to Australia to begin her new life, since she thinks the event has caused a detrimental impact on her family and herself. Next. Then comes to the judgment of the case. I will explain by stating the terms. First, under the Section 8A SDO, less favorable treatment of a pregnant woman is deemed discriminatory. The court considered that the fact of Ms. Chang's pregnancy was one reason for Jackson and Richard to make her to resign or to be demoted. They saw the pregnancy as a factor that they may be in their mind that the employee was unsatisfactory employee and would leave the company. The court also inferred that as she was pregnant, she would prefer to resign to be or to be demoted with her child. So the ultimatum of October the 23rd in 1997 was a discriminatory act. Next. On the basis of the same term, Ms. Chang's pregnancy and her complaint to the EOC were part of the reason Richard and Jackson decided to file a reporting request against her. However, the act is deemed discriminatory as well. The court also suspected that the salary increase differences for 1999 from the other product managers is tend to be a discriminatory motive. Then next, under another terms, Section 91 SDO, less favorable treatment consequence upon a complaint to the EOC is rendered discriminatory. The court found that the Jackson's written warning after Ms. Chang's second antenatal examination on January the 6th in 1998 was just based on that, as she has complained to EOC the case. As a written warning of the absence is a form of victimization. Also, considering that there was no good reason for Ms. Chang's poor behavior, the court held that Richard's refusal to give Ms. Chang an increase in salary in 1998 was based on she has complained to the EOC, so they regard the conduct of Richard's refusal as a form of victimization. Next. The court also supposed that the whole treatment of Ms. Chang was such as to entitle her to treat herself as being constructively dismissed, and that she was accordingly entitled to resign, as she did in July 2000. Then they decided to fix a date to consider the damages, other relief, and costs for the further hearing, and to find out if there are any other procedural matters that might involve in this case. Next. Under the management context of this case, I will propose two good practices. First is regulate working relationship dispute. There are two facts in this case. First, Jackson, he hated Ms. Chang and tell the truth to Richard. Second, the working style of the Ms. Chang and Francisca are totally different, as they are used a different method to deal with emails. So I suppose the manager should play a role to actively make employees convinced by explaining the values and missions to inspire them. Also, they had better not frequently put pressure to the employees. If they do that, the morale of the employees can be reduced, and they can learn. The employees can learn and become familiar with each other by communicating with each other and by open dialogues, which is a good way to improve their transparency between different or the same level as well. And the second practice is the company. The company can develop a performance appraisal software. Wealth has established an effective review management in this case, while the evaluation process in January 1998 was not so perfect, and there was a false assumption that Ms. Chang's actions required an ultimatum to resign or demote. The base of the action to resign had never been properly reviewed, and as long as the Jackson and Richard refused to accept their actions, there may be no justification. So, as an employee, if he's considered to be to not perform as the standards or instructions by their managers, they should be informed the relevant conditions to modify or evaluate before the bad actions are taken. Actually, the company if they are abundant in funds, they can develop an advanced software so as to improve the outcomes of the performance evaluation. First, it is good if it is fast and accurate. Also, the automation function can assist with the managers to review, to set objectives for the company, to make plans, and provide real-time information, etc. It can also bring convenience for both employees and employers. And finally comes to the conclusion. It is so common to see conflicts in the workplace, mainly due to the lack of clear guidelines on rights and duties of all parties. In this situation, employees and employers should take their rights and responsibilities reasonably to make everyone in the company understand and respect. And thanks for your attention. This is our presentation.